Hi, this is Wayne Zell, and welcome to Blueprint for Wealth, your fast paced video cast designed to help you realize your personal dreams of wealth and freedom. Today's educational moment is: who can sign a contract on behalf of your company? Companies come in all shapes and sizes. They have different types of entities, as we've talked about. So you want to look at the founding documents of the company or the organizational documents to determine who has the authority to sign your contracts, as well as the type of business that you're dealing with. There are many different types of businesses. Sole proprietorships, partnerships, limited liability companies, and corporations are the most popular. In the case of a sole proprietorship, it's not a separate entity. So the proprietor, the owner, is going to be the only person who has the power to sign a contract unless there is some instrument delegating authority to some other person. In a general partnership, which consists of two or more people formed together for a profit motive, any general partner has the power to sign on behalf of the entity unless there's a restriction in a partnership agreement. So it could be a minor partner, somebody who only owns, say, 5 or 10% of the partnership may have the power to bind the entity. If that's not your intent, then you need to make sure that you've addressed this decision in a separate partnership agreement. In other words, who has the power to bind the partnership? In a limited partnership, you only have a general partner and then limited partners. And generally, a general partner is the only person with the authority to sign because limited partners are only there as investors or passive participants. So a limited partner generally has no authority to sign on behalf of the company and should not have that authority because it may subject the limited partner to unlimited liability, which is what a general partner has. So the partnership agreement for the limited partnership should designate that the general partner is the only one that can bind the partnership. In a limited liability company or a corporation, these are separate entities and they're very different from the partnership structure. With a limited liability company, the founders of the limited liability company are known as the members. And normally, the person who has the authority to bind the LLC would be designated in the limited liability company operating agreement. If it's not designated there, then possibly any member of the LLC has the power to bind the entity. In a corporation, the officers of the corporation generally are authorized to bind the corporation as specified in the corporation's bylaws. So you really want to read your bylaws when when your corporate attorney gives them to you or when you create your corporation. And in the absence of bylaws, a stockholders agreement also could designate who has the power to sign on behalf of the company. You can also designate other people other than the officers to serve in the role of authorized persons who have the ability to bind the company. Many big companies, publicly traded companies, there are managers, directors, and others that are authorized under their bylaws to execute contracts on behalf of the company. If somebody signs on behalf of an entity but is not authorized to do so, it may render the contract null and void. So there has to be express authority to act on behalf of the entity. If you want to know more about how to execute a contract or to do it properly in accordance with the laws of the state in which you operate, contact your attorney. They're important components of your business planning process. Because your company depends on accurate enforceable contracts, it's important to review the agreements that you have currently in place and seek legal guidance to ensure that the right people have the right authority to sign on behalf of your business. Thanks for listening to Blueprint for Wealth. another educational moment designed to help you realize your personal dreams of wealth and freedom.